Imagine a legal system, hundreds of years old, built on this one core idea, that creativity is human.
Right. Uniquely human.
Exactly. This entire structure, this scaffolding that governs ownership, who gets paid, what identity means, it's all deeply baked into our civilization.
Hmm.
So what happens if a new technology comes along that just calculates its way to creativity, using nothing but probability and this high-dimensional geometry?
And suddenly, the core assumptions of that entire legal system just stop working.
They just cease to function?
And that's not hypothetical. That is precisely the crisis we are staring down right now with generative AI, specifically with large language models, or LLMs.
So this isn't just a challenge to intellectual property law. You're saying it's something more.
We're witnessing its conceptual collapse. Copyright, patent, trade secrets. They were all designed around human metaphors. The idea of a mind creating a fixed, tangible thing.
Artifact.
An artifact.
Yeah.
But AI operates on pure distributed mathematics. It's a completely different animal.
Okay, let's really get into this foundational failure. This deep dive, for everyone listening, isn't just speculation. It's rooted in some really extensive legal, technical, and even philosophical analysis.
Absolutely. We've gone through the classical IP theories. We've looked at the actual mechanics of how these LLMs work under the hood.
And we've reviewed that avalanche of high-stakes litigation from the last couple of years. Publishers, artists, AI firms.
The legal traffic jam.
It is. So our mission today is pretty radical. We need to understand in really granular detail why the old rules are failing and, crucially, what the new AI-native legal paradigm has to look like to govern this new reality.
And the core of the problem, you sort of nailed it earlier, is this mismatch of axioms.
Axioms.
Yeah. Traditional IP law, especially copyright, was built to regulate artifacts, fixed, discrete works, a painting, a novel.
Stable objects.
Exactly, stable objects. AI, on the other hand, produces events. They're statistical samples, they're probabilistic paths. The law is trying to force this geometric stochastic process into a linear human-centric box.
And the box is breaking.
The structure is fracturing under the pressure.
So to really get the severity of this, we have to go back to the starting line. Why do we even have IP rights in the first place?
It wasn't arbitrary, right? It was rooted in some really deep philosophical traditions, and every single one of them presupposes one thing.
A human.
A human creative subject.
Let's start with the oldest one then. The labor theory, right? John Locke.
Exactly. Locke's tradition. This theory says that when a human author puts in mental or physical labor, the work that comes out is an extension of that labor.
You put yourself into it, so you should own it.
Simple as that.
Okay, but here's the counter-argument I hear all the time. Someone still had to pay millions for the computing time. Someone curated the data set. Isn't that financial and organizational effort the new Lockean labor?
That's a great question, and it really highlights a critical legal distinction. It's the difference between a financial investment and creative labor. Lockean theory is about mixing your personality, your effort, that creative spark, with the raw materials. LLMs just calculate. They're non-agents, legally speaking.
So training the model, even though it's expensive, is just data processing.
It's mechanical.
Yeah.
You can't claim you mixed your creative labor with billions of computational weights to make a poem. The labor theory could maybe attach rights to the model itself.
As a trade secret or something.
Right. But it can't grant IP rights to the generated output on the basis of creative labor. It just doesn't fit.
So labor theory fails. Okay, what's next? The German tradition, Hegel. The personality theory.
Yes, this one is much more philosophical. It sees creative works as an emanation of a person's will, their identity, their moral character.
The work is an extension of the self.
And that idea just completely evaporates when you apply it to a machine. An LLM has no will, no identity, no continuity.
And certainly no moral agency.
None. We might talk about it like it does, the AI decided to, but it's just calculating the most probable next word. So personality theory finds zero conceptual foothold. The whole reason for moral rights, protecting the self's expression, is just absent.
Okay, so the philosophical arguments are shaky. Let's shift to the more pragmatic one, the one American law really loves.
The law and economics approach.
The incentive theory. IP exists to incentivize people to create, promising them a reward.
And this is where the challenge gets, really insidious.
How so?
Because LLMs produce limitless output without needing any incentive at all. They don't need a copyright payday to keep going. They just need electricity and data.
So the whole economic calculus is flipped.
Completely. The real concern here is that strong IP protection for AI outputs might actually distort human innovation. It gives this huge windfall to the model developers who didn't create the content, while at the same time discouraging human artists who just can't compete.
Against limitless, zero-cost cultural output.
How could you?
And that leads right into the final classical theory, doesn't it? The utilitarian social welfare theory. Balancing access and incentive for the greater good.
Right, but the foundational assumption of utilitarian theory is scarcity. We grant a limited monopoly IP to encourage production because production is hard or expensive.
But with AI, it's not.
It's not. If an AI can create 100 million high-quality images in an hour, what societal purpose is served by granting a 70-year monopoly over one of them? The entire justification just disappears.
So it doesn't matter if you approach IP from philosophy or economics, the foundation, the human creator, is structurally violated every time.
And that violation immediately triggers the collapse of the legal assumptions that copyright law absolutely depends on.
Which you've called the 6 ontological pillars of IP that LLMs invalidate.
Let's take them one by one, because this is the crisis the courts are facing right now.
Okay, pillar 1, human authorship, the most basic one.
It's the cornerstone. Copyright assumes a human author who perceived, expressed, made choices. LLMs compute. They don't perceive.
We saw this even before the AI boom, didn't we? With that monkey selfie case.
Exactly. Naruto v. Slater in 2018. The court was clear. A macaque can't be an author, no matter how good the selfie is. And the U.S. Copyright Office followed up on that in 2023. They were very clear. If a human doesn't contribute expressive content to the AI output, you don't get a copyright.
The machine's output is just raw material.
Uncopyrightable material, period.
Pillar 2 is intentionality. A work has to reflect deliberate creative choices.
And LLMs have no capacity for volition. What looks like a creative choice, like making a spaceship look a certain way, is really just a deterministic output. It's a calculation based on the prompt and the model's weights.
There's no preference, no meaning.
None. You see this in the Zarya of the Dawn case. The human prompt engineer only got copyright on the parts they manually added after the AI did its thing. The law is struggling to find the human intent in a purely computational process.
Okay, pillar 3, fixation. A work has to be fixed in a tangible medium. It has to be stable.
And this might be the most profound breakpoint of all.
Why is that?
Because LLMs produce infinitely variable, stochastic, non-reproducible outputs. Run the same prompt 10 times, you get 10 different results.
Because of the randomness, the temperature setting.
Exactly. An LLM output is a statistical sample. It's an event, not a fixed, stable work. So the whole doctrine of fixation can't attach to these ephemeral probabilities. How do you register a copyright for something that only exists as a non-reproducible moment in a computer?
You can't. Okay, pillar 4, originality.
The Feist standard. It has to be independently created and have a spark of creativity.
But LLMs are, by their very nature, derivative.
Structurally, mathematically derivative. They recombine these latent vectors derived from their training data. They don't create, they recompose. They're designed to find the most probable sequence.
And that's what's causing all the confusion in cases like NYTV OpenAI.
Yes. The court is struggling to tell the difference between a statistical reconstruction of a pattern and genuine human expression. Because sometimes they look identical.
Pillar 5, causal traceability. This is a big one for infringement cases.
Huge. Proving infringement requires a straight line. You had access to my work, and your work is substantially similar.
But that's impossible with an LLM.
Structurally impossible. An LLM's output is the result of billions of parameters, nonlinear transformations. A single phrase is the distributed result of maybe 50 billion weighted connections firing. You can't trace that phrase back to a single training example.
So the legal assumption is A causes B.
But the reality is A1 plus A2 plus, all the way to A50 billion, causes B. Judges all over the world have basically admitted they can't follow that causal path. It's a structural dead end.
And the final pillar, number 6, unitary ownership. A work has one owner or a simple joint ownership.
And AI outputs are these collective artifacts. They come from this hyper-complex ecosystem. You've got the prompt engineer, the owner of the training data, the dataset curator, the developer who built the architecture.
The fine-tuner, the platform that deploys it.
Right. Who owns the output? The law, which is built on the idea of a single human creator, has no natural person to assign ownership to. It creates these dizzying puzzles.
So when you see all 6 pillars, authorship, intentionality, fixation, originality, traceability, and ownership, all failing at the same time,
You get this conceptual crisis. It's unavoidable. The law has no answers because it doesn't even have the vocabulary to describe what's happening.
The core questions: who's the author? What is the work? They have no answers.
The answers are nobody, and no fixed work exists. The old doctrines have just run out of road. They weren't built for this.
Which brings us right into the technical reality of what's going on, because so much of the current litigation is based on what you called the mistake of analogy.
It is a fundamental mistake. Courts, lawyers, they often treat LLM outputs like human works. They assume the model stores and retrieves text or images, like a memory or a hard drive.
And that's just not how it works.
It's mathematically false. We have to understand the machine's mind, so to speak.
Yeah.
LLMs don't store sentences or images. They convert all that training data into a high-dimensional mathematical structure, a latent manifold.
It remembers the geometry, not the text.
Precisely.
Okay, let's break down those generative mechanics. Starting with that idea, latent space geometry, or LSG. How should someone listening visualize this geometry of meaning?
Think of it less like a library shelf and more like a colossal, high-dimensional Dewey Decimal System for meaning itself.
Okay.
Every concept, sadness, a horse, 19th century French poetry, it's all assigned a numerical location, a vector. And things that are semantically similar cluster together in this space. That's where the model's knowledge is stored.
So when you give it a prompt?
The prompt is converted into a vector, a starting point. And the output isn't a work, it's a path, a trajectory computed through that geometric structure. The model is just finding the most statistically efficient path from your prompt to the end of the sentence.
So it's not retrieving copyrighted data, it's navigating a map that was derived from that data.
Exactly. And that insight alone just invalidates the whole work-centered basis of copyright law. The legal object we should be looking at is the map, the topology itself, not the words it generates.
So if the output is just a path, how does the actual text get generated? That's the next step, right? Probabilistic token sampling, PTS.
This is the engine. The LLM generates text token by token, word by word, sometimes part of a word. Each new token is chosen based on a huge probability distribution.
So if you type, the cat sat on...
The probabilities for mat, couch, floor are all calculated and one is sampled. And that sampling involves randomness, the temperature setting.
Which is why you get a different result every time.
Infinitely many distinct outputs. Nothing is fixed. Copying requires a stable object to copy from. That object just doesn't exist in this system.
Which is the technical reason why fixation and originality collapse. But the real question is, who or what is making these decisions? That brings us to the parameters. Parameter ensemble decision-making, PED.
Right. The real engine, the true computational author, if you can call it that, is the billions of parameters, the weights.
And what are those exactly?
They're just numerical values that shape those probability distributions we talked about. They dictate which paths are more likely in the latent space. They aren't expressions. They aren't the training data. They're the decision rules.
They're the architecture.
They are the architecture. And courts are starting to realize how valuable these are. You see it in some of the Chinese AI parameter ownership cases. But traditional IP has no way to classify them. The parameters are the real unit of legal analysis, far more than the output.
And if you try to figure out why a certain output appeared, you run into this nightmare of nonlinear attribution cascades, NAC. This is where causation just dies.
Yeah, the analogy I like is trying to trace a single drop of water in a huge river system. You can't. It's flowed through countless tributaries mixed with billions of other drops. It's impossible to trace it back to one source.
The human law wants to see A caused B.
But an LLM is a distributed network, a nonlinear, multi-causal, irreducible system. So the legal requirement to show that this training example produced that output phrase is scientifically impossible. The entire foundation for proving infringement just dissolves.
And this brings us to the result that everyone sees, the one that frustrates artists so much. Style mimicry. When an AI generates something in the style of X, that's synaptic collective pattern recomposition, SCPR.
And it is so crucial to understand that the machine isn't reconstructing the artist's work. Is recomposing diffuse cultural patterns it's learned from millions of sources.
So it's not copying the old man in the sea.
No. It's extracted the low-level patterns of short sentences, certain rhythms, vocabulary density, all the things that define that style.
Yeah.
And it's reapplying those patterns.
Yes, which is why style infringement arguments, like in Anderson v. Stability AI, keep getting dismissed.
Because current copyright law is explicit. You can't protect a style. The model extracts the pattern, not the expression, and the law only protects the expression.
So the technical reality is just unavoidable. LLM outputs are statistical events, They're trajectories. They're not works, copies, or derivatives.
And any legal doctrine built on that human-centric metaphor is, as we said, structurally incompatible.
Okay, so if retrofitting the old law is a spectacular failure, we have to start over.
We have to abandon the human metaphor and adopt a framework that's derived from the machine's architecture itself. We need a legal grammar that matches the technical reality.
And this is where you introduce the 5 emergent theories, a new AI-centric legal paradigm.
Exactly. These theories reconceptualize the whole problem. The output isn't a fixed work. It's a legal event, a trajectory, a manifestation of the algorithm's topology.
So after that structural collapse we talked about, where do we start rebuilding? You say the first shift is something called probabilistic composition rights, PCR. If the output isn't a fixed work, what is the thing we're protecting?
The legally relevant unit has to shift. It can't be the surface text, that fleeting sample. It has to be the underlying probabilistic configuration, the potential distribution of outcomes the model is designed to produce.
Wow, okay. That's a radical shift. Fixation becomes totally obsolete.
Completely. And infringement under PCR wouldn't be measured by comparing two sentences. It would be measured by comparing probability fields, distribution overlap.
So what does that look like in a real case? Say I'm a musician, and I think an AI is ripping off my style. How does a court measure distribution overlap?
Well, instead of a judge listening to two melodies, an algorithmic court would analyze the statistical distribution of, say, chord progressions or rhythmic complexity generated by the AI model.
A histogram.
A histogram, exactly. If the distribution histogram of the AI's potential output overlaps too closely with the probabilistic boundaries of your copyrighted music catalog, that's infringement.
So you're regulating the potential for copying.
The potential, not just the single instance. And this is how you start to resolve those statistical reconstruction disputes, like in NYTV OpenAI or the big music cases in Europe.
Okay, that's theory 1. Theory 2 gets at the geometry we talked about. Latent space rights, LSR.
LSR says that the high-dimensional latent space itself, that huge, intricate map of meaning, is a protectable and regulable legal object. It's totally distinct from the text that trained it.
So infringement can happen inside the model's brain, so to speak.
Yes. We call it latent exploitation. It can happen even if the model never generates an output that a human would recognize as a copy.
So let me see if I get this. If I train a model on public domain books, but then I use my own proprietary math to organize that latent space into a really efficient topology, it's the topology that's protected.
Exactly. And this maps directly onto the core fight in Getty Images v. Stability AI. Getty is arguing that just encoding their images into latent space is a form of copying. LSR says, yes, the geometry is the legal object, but we need to regulate the exploitation of that manifold. We need to treat latent space like a proprietary asset that can be licensed and audited.
Okay, moving even further inside the machine. Theory 3, constitutive parameter rights, CPR.
Since those billions of parameters are the actual engine, the decision rules for the whole system, rights should attach at the model architecture level.
So this is more like patent law or trade secret law?
It's closer, yes, but it shifts the IP focus completely away from the output and onto the internal machinery. We would treat complex parameter setups like we treat chemical formulas or DNA sequences.
Protect the parameters, you protect the ability to generate the output.
That's the idea, and it directly addresses the kinds of issues we're seeing in those Chinese parameter ownership cases, where they're recognizing the weights as these incredibly valuable, protectable assets.
Theory 4 tackles the causation problem head-on. Nonlinear attribution theory, NAPI.
We've established that linear causation is a dead end. So liability and ownership have to be defined through these nonlinear influence networks. We have to throw out the simple access plus similarity equals copying standard.
So under NAT, what does it follow?
Liability has to follow influence intensity, not a simple linear cause.
How would that ever work in a courtroom?
Instead of proving the AI copied a specific phrase, you would prove that influence from a protected latent cluster was the statistically dominant factor in generating the output.
So you could assign blame proportionally.
Precisely. If the user's prompt contributed 10% of the vector weight, the fine-tuner contributed 40%, and the developer's foundational model contributed 50%. Liability for a harmful output gets assigned proportionally. It gives judges a mathematically grounded way to assign responsibility.
And that leaves Theory 5, which addresses that huge style mimicry problem, synaptic collective pattern rights, SCR.
SCR is the answer to the current legal vacuum. It recognizes that style, pattern density, cultural attractors, all these things that LLMs are so good at extracting, they're collective properties, not individual copyrighted works.
So it creates a whole new category of rights.
A new category of style rights or collective culture rights that are legally recognized. It gives a path forward for artists who are being harmed by this pattern exploitation. It fills the void you see in Anderson v. Stability AI, where the court basically had to say, sorry, style isn't protected.
But under SCR, the extracted pattern itself becomes the protectable unit?
Yes, regulated collectively.
So these 5 theories, PCR, LSR, CPR, NAT, SCR, they're not just tweaks. It's a whole new legal language built from the machine up.
But having the theories is just the blueprint. You run into the enforceability problem.
Right. Traditional IP works because human works are stable, they're traceable, they have authors. LLMs break all of that.
Which makes the traditional remedies totally unadministrable. We can write new laws, but how do we actually enforce them in a way that respects the tech?
So we need new legal objects to protect. This is where you talk about protected generative units, PGUs, the actual statutory definition of what's being regulated.
Exactly. The law has to stop thinking about a fixed document or a melody. Under this new paradigm, the PGU is a specific, measurable technical concept.
So for PCR, the PGU is the probabilistic construction pattern.
Right. For LSR, it's the latent geometric cluster. For CPR, the parameter ensemble itself. And for SCR, it's the pattern density signature. These would be defined in law, just like we define the protectable boundary of a DNA sequence in patent law today.
And when one of these PGUs is violated, who's responsible? Ownership is collective, causation is distributed.
So you need the 5-theory attributability model, FTAM. It shifts liability away from a single author and distributes it proportionally across the whole chain of influence.
So you have the 5 subjects.
The prompt user, the model developer, the training curator, the fine-tuner, and the deployment platform. Responsibility is assigned using influence weights and parameter contribution analysis.
Okay, that sounds astronomically complex. Is this really necessary? Can't we just have special expert witnesses explain the code to judges?
It is absolutely necessary. The scale and opacity of these systems make human interpretation of raw vector spaces impossible. We can't have a few experts decoding trillions of matrix multiplications for every case.
So you need new institutions.
We need algorithmic responsibility courts, ARCs, supported by specialized algorithmic legal infrastructure.
Yeah.
It's no different than how DNA forensics required specialized labs and rules of evidence.
What tools would these ARCs actually use to make this work?
They'd need 3 core technical protocols. First, model fingerprinting. Developers would have to store certified auditable snapshots of their model's parameter clusters at different stages.
For retroactive attribution.
Exactly. Second, latent trajectory logging. Every output has to be tied to a recorded path through the latent space. It's a machine-readable chain of custody.
I see.
And third, the parameter contribution audit, PCA. This is what makes the nonlinear attribution theory work. The PCA shows the mathematical breakdown of influence.
So it would literally say, this output was 60% driven by the developer's architecture, 30% by the fine-tuning, and 10% by the user's prompt.
Precisely. It allows courts to assign proportional liability without having to become computer scientists.
Taking this all the way up to the policy level, you advocate for latent space governance, LSG. If latent geometry is where cultural value now resides, we have to manage that topological structure.
That sounds huge.
It is huge, but it's necessary. Policymakers have to define zones within this conceptual geometry. We propose creating public latent zones, PLZ,
Meaning?
manifolds that are derived solely from public domain data. They'd be classified as shared cultural geometry where no single company has exclusive ownership rights.
Wait a minute. Isn't defining these zones just another way of privatizing the public domain's geometry? It seems like this would be wide open to regulatory capture by the big tech firms who can afford to map this space.
That is the #1 risk, and it has to be managed with open source protocols and transparent audits, but the alternative is worse.
Failing to define any boundaries at all. That means the developers who build the foundational models implicitly own the entire geometry by default. They privatize the process of accessing public data.
And then you'd have the opposite of a public zone.
Proprietary latent zones, PRZ. These would be eligible for LSR protection, requiring licensing and audits to access those specific semantic areas that were refined using proprietary data. LSG is about asserting democratic control over the topology of knowledge before it's completely ceded to private hands.
The chaos in the courts today really signals that judges are just improvising. They don't have the words for these problems.
But these new theories could offer that necessary language.
So let's bring this to life. Let's make some predictions using these emergent theories.
Okay, let's start with the biggest one right now. NYT v. OpenAI. Let's predict a 2026 decision. The New York Times argues that training the model is mass copyright infringement.
Right. And under existing law, that whole argument gets bogged down in fair use. And is it transformative enough? It's a mess.
But under a framework using PCR and LSR, the court's decision would be totally different. It would likely say something like, LLM training is the non-expressive transformation of text into latent geometry. Copyright governs expression, not topology. Therefore, the claim fails under existing copyright law.
Because the input material wasn't copied in an expressive sense.
It was mathematically transformed into a non-expressive utility asset. The judgment focuses on the nature of the asset, the geometry, not the input text.
Okay, what about Getty Images v. Stability AI? Maybe a 2027 decision?
Getty's argument is that Stability AI used their watermarked images, and now the model mimics their style and sometimes even spits out their watermark.
And under traditional law, Getty has a huge hurdle because you can't copyright a style.
Right.
But under Synaptic Collective Pattern Rights, SCR, the court would say, yes, the claim fails under traditional copyright because style is unprotected. However, the court would explicitly recognize that Stability AI extracted identifiable stylistic manifolds,
Which are legitimate legal units under this new SCR regime. Yes. The court would basically provide a clear roadmap for a new legal tort. It would recognize the harm, even while dismissing the claim under the old broken law.
So let's jump to a hypothetical but inevitable 2029 case. Let's say it's the Artist Guild v. Midjourney, and it's focused entirely on the unauthorized extraction of cultural patterns and artistic styles.
This is where SCR finally gets operationalized. Under SCR, this court would recognize a limited pattern exploitation tort, completely separate from copyright.
And that tort would protect what?
It would protect identifiable cultural pattern clusters, specific gesture vectors, color palettes, thematic structures that are extracted from a body of human work.
So it shifts the focus away from an individual artist's copyright.
And toward the collective governance of shared aesthetic patterns. It recognizes the model is stealing the recipe, not the cake.
And one final one, the inevitable hallucination liability case in 2031. An AI generates something harmful and false, a fake legal precedent, a defamatory image that causes real-world damage. You can't trace the cause.
So under nonlinear attribution theory, NAT, the court abandons the search for a single cause. It would impose proportional liability across the user, the developer, and the fine-tuner.
Using the tools we talked about.
Exactly. The court would use the parameter contribution audit, PCA, from the NAT framework to assign responsibility. If the model hallucinated because of a known flaw in the foundation model, but it was triggered by a specific prompt.
The court creates a multi-actor influence curve.
Right. Maybe 60% liability to the developer, 40% to the user. It creates a new standard for distributed accountability where none exists today.
This deep dive really makes it clear that the structural collapse of IP law isn't some future problem. It is happening right now in courtrooms all over the world.
Yeah.
And the law can't be saved with just a few tweaks. It has to abandon those human-centric metaphors, authorship, fixation, intention.
And adopt constructs that are rooted in the technical reality. Probability, latent geometry, nonlinear attribution.
The failure is, as you said, axiomatic, not transitional.
We're trying to govern a technology built on statistical prediction using laws built for singular human behavior. The 5 emergent theories, PCR, LSR, CPR, NAT, and SCR, they provide the only coherent mathematically sound foundation for a workable system.
And this goes way beyond just legal theory. It hits market efficiency, incentives, and ultimately democratic control over our own culture.
It does. If the law fails to recognize and regulate these new computational structures, if it fails to define something like latent space rights, the consequence is inevitable.
The few big tech firms who build these models will implicitly own all latent spaces. They'll indirectly privatize all public cultural data.
To ignore latent geometry is to willfully ignore where creative value actually lives in the AI era. It means the recipe for all of human culture is contained in a topology owned by a handful of private companies.
Which leaves you listening with a pretty crucial and powerful question.
If the value of our culture is now contained in mathematical topology, What happens to democratic control if we fail to regulate that geometry?
It's a paradigm shift that demands we act now.
It is.
The future of creativity really depends on recognizing that AI doesn't just challenge IP, it demands we reinvent it. From the ground up, now go out and start thinking about those geometric clusters.